Solomon Price was 41 years old, a real estate attorney who had spent 15 years explaining to other people why the thing they believed they owned was not on paper theirs. He filed the documents the same way he filed everything, precisely in the correct drawer, in the correct order labeled. On a Saturday morning in April, he pulled into his own driveway to find a white locksmith van parked at the curb, the front door propped open, and hardware laid out on the porch steps. His wife was inside. A man he recognized from 2 months of filed-away observations was standing near the kitchen doorway. His wife looked at Solomon when he walked through the door, the way people looked when they had prepared for a different opening. Scene. She said she was having the locks changed. She said she needed him to leave. She had decided, at some point in the months prior, that the house was hers to decide about. Solomon went to his office. He opened the middle drawer of the filing cabinet. He took out the deed. He walked back to the front door and handed it to the locksmith. The locksmith read it. He closed his toolbox. He thanked them both for their time. He left. She had no idea what she had actually been standing on. Before we jump into the story, comment where in the world you are watching from and subscribe, because tomorrow's story is one you need to hear. The office was cold and quiet at 6:19 in the morning. Solomon had the good coffee going before the light came up. Solomon Price had spent 15 years practicing real estate law, with a specialty in title disputes, the cases where someone had been living in a property for years and had to be told, with documentation, that possession and ownership were two different things. He had filed his first title dispute at 27, a case involving a man who had paid taxes on a parcel for 19 years without ever establishing that the title was clean. He had understood then that most people move through the world without reading the documents that governed it. He had never made that choice for himself. He drove a green sedan he'd had for 6 years. He kept a mechanical pencil in his breast pocket at all times, a habit from law school, annotating in margins, thinking on paper, and replaced it when the barrel cracked, which was every 2 to 3 years. He had an original recorded deed for every property he had ever touched in a labeled section of the filing cabinet in his home office. His own deed was in the deed drawer. He knew exactly where it was. He had always known exactly where it was. He was the kind of man who read the fine print before the front page. He had bought the house 7 years ago, 1 year before he met Candace. He had spent the following year renovating it himself, not the structural work that he hired out, but the finish work. The tile in the bathroom, the kitchen backsplash he laid over 3 consecutive weekends. The trim in the study he sanded and painted himself because he wanted the room to be right. He had moved in when it was done, and it had felt at that point like something that was entirely his. He and Candace had been married for 4 years. She was organized, sharp, had a quick intelligence about people that he respected. He had believed she saw things clearly. He had extended that belief past several signals that, in any other context, he would have read correctly on the first pass. He didn't know then that she had been deciding, for the better part of the past year, that the house was as much hers as it was his. He had not corrected that impression because he had not known it had formed. He would later note that, as the one assumption he had failed to examine. The morning was bright and ordinary when he pulled into the driveway. He had been at a weekend title review for a commercial client. 3 hours of documents, the kind of Saturday work that simply needed to be done. He had called ahead. Candace had not answered. A white van was parked at the curb, lettered on the side, the name of a locksmith company and a phone number. The front door was propped open with a rubber wedge. On the porch steps, a set of new deadbolts, still in their packaging, and a power drill set to one side. Solomon turned off his car and sat in it for 4 seconds. Then he got out. The living room smelled like the pine candle Candace kept near the window. Candace was standing near the back of the room. A man Solomon recognized from a pattern he had been quietly tracking for 2 months was standing in the doorway to the kitchen. He was wearing a casual jacket with a small embroidered logo on the chest, the name of a local real estate development firm that Solomon had professional familiarity with. He noted it. He said nothing. The locksmith was at the front door, hardware in hand, measuring the existing deadbolt housing with a practiced eye. Candace looked at Solomon, the way someone looked when the scene had not opened the way they had rehearsed. She adjusted quickly. "I need you to go," she said. Her voice had the quality of something prepared, delivered at the moment she had selected. "I'm having the locks changed. I need you to understand that I'm serious about this." He looked at her. He looked at the man near the kitchen door. He looked at the locksmith. He didn't say what he was thinking about the specific legal definition of unlawful lockout. He didn't say anything about the man with the embroidered jacket or what Solomon knew about the firm that logo belonged to. He didn't raise his voice. He set his bag down near the door with the same deliberate placement he gave everything. He went to his office. He opened the middle drawer of the filing cabinet, the D section, property, exactly where it had always been, and removed the original recorded deed. He walked back to the front door. He held the deed out to the locksmith. "Before you proceed," Solomon said. The locksmith set down his drill. He was a professional. He had his own protocol about jobs like this one. He had seen enough disputed occupancy situations to know what a property deed meant for his liability. He took the document, he read it again. He looked at the name on the deed. He looked at Solomon. He looked at Candace. He looked at the hardware on the porch steps. He began placing his tools back in the box. "Ma'am," he said, "I'm not able to complete this job." "What?" Candace started. "The titled owner is present and on the premises," the locksmith said. He set the package deadbolts on the porch railing. He picked up the toolbox. "I appreciate your time." He loaded his van. He drove away. Solomon folded the deed and put it back in his breast pocket. He looked at Candace. He looked at the man near the kitchen, who had not moved and had not spoken, and was now looking at the floor with the particular expression of someone reassessing a situation. "I'll be in touch through an attorney," Solomon said. He picked up his bag. He went to his office and closed the door. He sat at his desk and opened the mechanical pencil and made 3 notes on the legal pad in front of him: the embroidered logo, the development firm's name, the date and time. He had been practicing real estate law for 15 years. He knew exactly what to do next. 3 years before that Saturday, Solomon Price had done something that had never come up in conversation. Candace had been in a dispute with a former employer, a wrongful termination matter, relatively clear-cut, but requiring an employment attorney and a process that would take 8 months and cost real money. She had a case. She didn't have the retainer. Solomon had paid it, the full amount. He had done it without discussion. The same way he handled things he had decided were simply the right thing to do. He had introduced her to a labor attorney in his network and had stayed out of the case entirely after that because it was hers. She had won the case. She had never mentioned the retainer to anyone. In the year prior to the Saturday, he had noticed Candace beginning to refer to the house in ways that carried a different weight than they had before. The way she described it to guests, the way she referenced it in conversations about plans. She had begun to speak about it with a particular proprietary confidence that he had not heard before. He had filed this observation with the same quiet precision he filed everything, without announcing to himself yet what it meant. There was a woman named Marvette Cole, who had been handling title searches for Solomon's firm for 12 years, and who lived 3 blocks from the house, who had said to him at a firm lunch the previous fall, in her measured, unambiguous way, "I want you to know that I see things from where I live, and I want to be available if you ever need someone who keeps good records." He had asked her what she meant. She had looked at him the way she looked at title searches that came back with irregularities. "I'll tell you when you're ready to ask," she said. He had thought about that more than once in the months that followed. He had been ready by the Saturday of the locksmith to ask. That was what Candace hadn't understood, until the locksmith read the deed and packed his tools. Her name was Marvette Cole. She was 65 years old, a retired title examiner and licensed notary who had spent 31 years processing property records for a county title office before joining Solomon's firm as a senior contract examiner. She was deliberate and small, with silver locks she wore pinned back, and a way of presenting documents that communicated their contents before she had said a single word. She had been keeping records for 7 months. She had not come forward yet because she had been building the complete picture first. She had wanted to arrive with evidence, not concern. She called Solomon on the Monday after the Saturday. She said she had something to show him. She said, "Eat first." He met her at her kitchen table at 7:30 in the morning. She was already seated. On the table in front of her, arranged in 2 groups with the precision of a woman who had spent 3 decades making sure documentation held up under challenge, were the materials she had compiled. "I'm going to take you through what I found," she said, "in the order I found it. I need you to stay with me until I've finished." The first group contained a single document that had come to Marvette's attention 3 weeks prior. a title search request, routine on its surface, submitted by a mortgage broker Marvette recognized, referencing a residential property at Solomon's home address as collateral for a home equity loan application. The borrower of record, Candace Price. Co-applicant, listed as co-owner Solomon Price. Marvette set a second document beside the first, a copy of the signature page from the loan application. Two signatures, one in Candace's hand, one that was represented as Solomon's. "I've been notarizing documents for 28 years, Marvette said. She looked at him steadily. "That is not your signature." Solomon looked at the signature. He looked at it the way he looked at any document that required his complete attention. He set his mechanical pencil flat on the table. He looked at the document without it. He had not signed anything related to that property address in over 4 years. He was certain of this the way he was certain of things he had personally recorded. "The loan amount?" he asked. $94,000. Marvette said, "What was it for?" She turned to the second group. 3 documents. The first was a business registration, a joint venture formed 5 months ago. One of the registered members was Terrence Howell. Solomon looked at the name, then at the embroidered logo he had noted in his home office. The development firm. He looked at both. "Terrence Howell is a project acquisition manager at Aldrin Group," Marvette said. "They've been trying to close on a parcel in the North Corridor for 18 months. They've had financing gaps." She set the second document on the table, a parcel map and a project cost summary. The projected capital needed to close the acquisition gap, approximately $90,000 to $100,000. Solomon looked at the parcel. He knew the North Corridor. He had done title work on 3 adjacent parcels in the same block. He did not say anything for a moment. "She didn't know what she was doing," he said. "Not as a defense, as an assessment." "She knew she was taking money from the equity," Marvette said. "I don't think she understood the full shape of where it was going." She placed the third document on the table, a notary verification request. The lender had flagged the co-applicant's signature for verification and submitted it to Marvette's office as part of their fraud prevention protocol. "The application is still in process. It is not closed. The lender is waiting on the verification." Solomon stood. He went to the window for a moment. He looked at the street. Then he came back. He sat down and spread all the documents across the table the way he spread deeds and plat maps on his conference room table, not looking at any single piece, looking at all of it together: the loan application, the forged signature, the LLC, the parcel, the financing gap that the $94,000 was meant to fill. He had handled 300 title disputes in 15 years. He had explained the same concept to 300 different people. That a document recorded in a county office was a fact, not a negotiating position. He had just never expected to be the subject of that explanation. He could see the whole shape of it. "I need to call Gerald," he said. "I know," Marvette said. She set a cup of coffee in front of him and did not say anything further. He didn't move fast. That's what people never understand about this part. Gerald Washington had been Solomon's litigation attorney for 8 years, the person Solomon called when a matter moved beyond real estate law and into the territory of people doing things they should not have done. He was methodical, deliberate, and called at 6 a.m. when the matter required it. Solomon reached him on the Monday evening, and they met at Gerald's office on Tuesday morning with all of Marvette's documentation. Gerald read it without speaking for 19 minutes. Then he set it down. "The forged signature is the lead matter," he said. "Mortgage fraud, civil and potentially criminal, depending on how the lender wants to proceed. We contact them today and halt the application. They'll want to do that regardless once we flag the co-applicant signature issue." He turned to the second section. "The Aldrin Group connection is secondary but worth preserving. It establishes intent and beneficiary, which matters if this goes further than the civil track." He looked up at Solomon. "The deed itself," Gerald said, "puts her claim on the marital home in a very specific posture for the divorce proceeding. Premarital purchase, sole title, never retitled. In this state, the analysis is not simple, but her starting position is weaker than she currently believes." Solomon nodded. He said, "I want the application stopped. I want the record accurate. That's the beginning and the end of what I want." Gerald said he would have the lender notification drafted by end of day. Candace called on the Wednesday. She had the voice of someone who had rehearsed 2 versions of the call and was deciding in real time which one to use. She said she was sorry about the Saturday. She said she had overreacted. She said she wanted them to talk like adults about the situation. He said he appreciated the call. He said his attorney would be in touch. She called again Friday. Her second call had a different quality from the first. Less warmth, more information gathering, the way a person called when they had started to feel the ground shift, but couldn't yet identify what had shifted. She asked if he was still in the house. He said he was. He said he had no intention of going anywhere. He didn't move fast. That was the thing she had not once thought to account for. She had spent the months prior deciding that Solomon's patience was the same as passivity. She had watched him go to work, come home, sit at his desk, file his documents, answer his calls, maintain his routines, and she had decided it meant he was not paying attention. She had made the same mistake that every person made who had ever called his office, demanding something they did not own. She had confused his stillness for the absence of awareness. He had been paying attention since November. He called her on the following Thursday. His voice was even, cooperative, the tone he used in settlement mediations, where he wanted the other party to feel the proceeding was still open. He said he thought they could handle the property matters without full litigation. He said he wanted to be fair. She agreed before he finished the sentence. She said Terrence was going to come to the meeting. Solomon said that was fine. He ended the call and noted the time in his legal pad. Then he called him, Solomon said. Gerald said good. He did not explain further. Marvette was in the chair across from his desk. She had been there through the entire call without speaking. She's bringing Terrence Howell, Solomon said. Marvette looked at him over her reading glasses. She reached into the small bag she always carried and produced a thermos. She filled his mug without being asked. Then she went back to the document she had been reviewing. Solomon arrived 35 minutes early. He had always arrived before the other parties. In a title dispute, the attorney who arrived first set the physical terms of the room. He had never unlearned this. The conference room was on the 6th floor of Gerald's building, a room with a rectangular table, clean walls, and a window looking east over the city's older commercial district. Solomon had been in this room before for other matters, representing other clients. He knew its dimensions and its light. Gerald arrived at 9:38 with his associate. Marvette arrived at 9:44 and sat near the window with her folder and her reading glasses and said nothing. The room settled into the quiet of people who had done this kind of work before and knew what it required. Candace arrived at 10:01 with her attorney, a man named Charles Byrne. She was dressed professionally, carrying a folder she had prepared, moving with the composure of someone who had made a decision and intended to hold it. She nodded at Solomon briefly, the civil nod of a formal proceeding. Terrence Howell came through the door behind her. He was dressed well, carried himself with the ease of a man who had decided the situation was under control. He sat beside Candace in the way of someone who had been told this was a support role and believed it. He glanced at Solomon with a casual assessment of a man who had already categorized what he was looking at. He did not appear to recognize the room for what it was yet. Gerald opened the meeting at 10:04. Thank you for coming. Before any discussion of property matters, there are several items that need to be on the record. Byrne said, our understanding was that this was a preliminary settlement. These are preliminary, Gerald said. His voice was pleasant and immovable. He opened his folder and began placing documents on the table. The first was the home equity loan application. Gerald walked through it, the address of the property, the borrower, the co-applicant listing, the loan amount of $94,000. The co-applicant on this application, Gerald said, is listed as Mr. Solomon Price, with a signature represented as his authorization. He set the signature page on the table. Mr. Price did not sign this document. This has been confirmed by a licensed notary who has been familiar with Mr. Price's signature through professional work for 12 years. He set Marvette's notary analysis beside it. A fraud notification has been filed with the lending institution. The application has been halted. Candace's attorney had stopped writing. He looked at the documents. He looked at his client. She was looking at the signature page with an expression that had gone very still. The second matter, Gerald said, placing the next document on the table, concerns the intended use of the loan proceeds. He set the LLC registration on the table. He walked through it. The formation date, the registered members, the described purpose. He set the project cost summary beside it. He set the parcel map beside that. The capital gap in this acquisition project, Gerald said, is approximately $90,000 to $100,000. The loan application against Mr. Price's property was submitted 5 weeks after this LLC was registered. He looked at both sides of the table. We are presenting this as context for the fraud matter. We are not characterizing it further at this time. Terrence Howell was no longer at ease. He was reading the LLC registration document with the specific attention of a man who had just found his name on a table he had not expected to be named on. His expression had moved through several adjustments in the space of 10 seconds. He leaned toward his own attorney. He had brought one, which Solomon had noted when he walked in, and said something low and urgent. Finally, Gerald said, setting the deed on the table, the property itself. He placed the original recorded deed flat, Solomon's name clear at the top. The residence at this address was purchased by Mr. Price 7 years ago prior to the marriage, and has remained solely titled in his name. It was never retitled as a marital asset. Under the applicable state statutes, the characterization of this property in any settlement discussion begins here. He set the deed beside the application and the LLC documents and let the three of them sit together on the table. Candace was looking at Solomon. He had not looked at her during the document presentation. He looked at her now. He held it long enough for her to understand that the Saturday morning had not surprised him, that the deed had been in the correct drawer the entire time, that he had known, long before she called the locksmith, exactly what the record said. Then he was done looking. He stood. He picked up his mechanical pencil from the table and put it in his breast pocket. He buttoned his jacket. He shook Gerald's hand. He looked at Marvette once. A brief look, nothing more, and nodded. He walked toward the door. He stopped. He looked back at the table. Not at Terrence, not at Candace's attorney, at Candace. He said it quietly, without the need for volume. I've spent 15 years explaining to people why living somewhere and owning something are two different things. He paused, not for effect, because it was simply true and he wanted to say it accurately. I didn't think I'd need to explain it here. He walked out without looking back. It did not happen all at once. The lender's fraud investigation ran for 11 weeks. At the end of it, the matter was referred for review by the county prosecutor's office. Gerald managed the process with the same unhurried precision he brought to everything. He was careful about scope. The fraud matter named what it named and nothing more. Solomon had not asked him to widen it. Terrence Howell's acquisition project for the North Corridor parcel stalled in the 3rd month for reasons that had nothing to do with Solomon directly. The financing gap remained a gap. The LLC registered to close it was dissolved in the fall. Aldrin Group reassigned the project to another manager. These were procedural outcomes, not designed ones. Solomon had simply made sure the record was accurate, and the record had done what records did when they were accurate. Candace's claim on the marital home was resolved in the 4th month of proceedings. The deed had said what it said since the day it was recorded. The settlement was equitable within those terms. Solomon had not sought more than was his. He had never needed to. He had 4 attorneys in his practice now. He was bringing on a 5th in the new year, a young title specialist, sharp, just past the bar, the kind of person who read the full document before forming an opinion. He answered every client call the same day. He gave accurate timelines. He hit them. 14 months after the reckoning, Marvette sent him something through the mail. No note, a small plant in a clay pot, angular and low maintenance, the kind that grew slowly and reliably and didn't need much. He put it on the windowsill in his home office between the filing cabinet and the window. He watered it on Thursdays. One afternoon in November, Gerald stopped by the office for a signature review and stayed for a cup of coffee. He looked around the office, the deed on the wall, the filing cabinet, the labeled drawers, the plant catching the afternoon light. Organized as ever, Gerald said. Everything has a place, Solomon said. Gerald nodded. He picked up his cup. He said nothing further. That was the thing Solomon had always respected about Gerald. He knew when a thing had been said. On a Sunday morning in late November, Solomon Price stood in the kitchen of the house he had owned for 7 years and poured his coffee and looked at the backsplash he had laid himself over 3 weekends 8 years ago. Pale gray tile, hand-cut at the corners, a small flaw in the 3rd row that he had decided to leave because imperfection in handwork was honest. The morning light came through the east window the same way it had always come through, at an angle, striking the tile at a specific time of morning that lasted about 18 minutes before the sun moved. He had stood in this same kitchen the weekend he finished the backsplash, coffee in hand, to see if it had turned out right. It had. He finished his coffee. He set the mug in the sink. He went to his desk. His name was already on the deed. In the morning, he would return to the work. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.